Every week, as you know, Rich, we like to do business and the law, law and business. And if that's what we're doing now, we have Mark Furman from Tarlow, Breed, Hart, and Rogers. Welcome, Mark.
Hello, Jeffrey and Rich. Great to be with you today.
Thanks. So, Mark, what's the story?
So I wanted to talk about actually it's a products liability case, but it affects, business. So we have a painting that was hung from the wall, and the picture hangers failed, and these were very valuable painting. The canvas was torn, thereby destroying the painting. And AIG was actually the insurance company. They paid the claim. So as happens, they are subrogated to the rights of their insured. They go ahead and sue the seller and the manufacturer of this hanger. It's basically nail and accoutrements and that were used to hang the painting. So one of the defendants is a not present in Massachusetts. Suit gets filed in Massachusetts, where the damage occurred and where the insured's loss occurred. And so that party, retained counsel, filed an answer, and one of the claims that they asserted was a lack of personal jurisdiction, because you can't just, if you're a company, you can't just be sued any place in the United States, no matter what the circumstances. You have to have a minimum amount of contacts with that state. Otherwise, it's considered a violation of your constitutional rights to be hauled into court in a place where you conduct no business, that you don't purposefully avail yourself of business activity and use the courts and obtain revenue and the like. So this company had an excellent claim to seeking dismissal for lack of personal jurisdiction. But for some reason, they just included this as a defense among other defenses, but then didn't move to dismiss the case right away. And in fact, they got involved in litigating the case. They conducted discovery, both on the merits of the case and on this question of personal jurisdiction. They filed motions. They filed other types of pleadings in the case. And finally, at the end of discovery, after a long period of time had gone by, they moved for summary judgment, a common thing to try to avoid a trial, where they claimed that there was a lack of personal jurisdiction. So the whole idea of no personal jurisdiction is my company shouldn't be forced to litigate in a place with which I have no connection.
And the message to entrepreneurs is?
The message to entrepreneurs is you have a claim. Well, my message always is, if you make sure that you review your insurance coverage, it's always helpful to have insurance coverage if possible. But in this situation where we don't know whether there was insurance coverage for the defendant, there are strategy issues around what defenses to assert, how to prosecute them, what form do you want to be in. Do you have a defense based upon the inconvenience of the forum or lack of personal jurisdiction? Do you want to waive that defense or risk waiving it for other strategic reasons? Because litigation is a process that everybody who's a party to can become a victim of, and what lawyers need to do is try to minimize how their clients are victimized by the very complicated, expensive litigation process. So sometimes that requires waiving defenses because of other strategic reasons or the cost of asserting those defenses. So early legal advice is can be very helpful.